Hello, my name is Albert Barsocchini, and I'm Assistant General Counsel at Guidance Software. Today, I'd like to talk about the risks and costs of self-collection and e-discovery processes. The risks of custodian self-collection include non-compliance, under-collection, metadata alteration or spoliation, inadequate documentation of chain of custody, authentication challenges, and business disruption. While most attorneys acknowledge the potential pitfalls of custodian self-collection, many grossly underestimate the actual risks and costs involved. Take a recent bankruptcy case involving Hawaiian Airlines. A principal witness in the lawsuit received a legal hold notice and responded by deleting relevant evidence. The court issued an adverse inference instruction against the company because it simply told the custodian to preserve all evidence and trusted him to comply, rather than taking reasonable steps to prevent spoliation. The company was held to have facilitated the misconduct even though the custodian acted in bad faith. Spoliation is only one of many critical issues corporations are experiencing with custodian self-collection. In the recent Qualcomm case, attorneys were sanctioned and referred to the State Board on alleged ethics violation because a fact witness computer contained relevant evidence that was not produced prior to trial. The critical electronic files were discovered just prior to the witness's trial testimony and had existed on the witness's computer for 4 years prior to trial. This clear trend in case law shows that companies are ill-advised to rely on custodian self-collection. Simply having a litigation hold notice go out and acknowledged by the end user is not sufficient good faith to insulate the client and attorneys from sanctions. Moreover, the sheer volume of ESI continues to increase even for smaller cases. A single personal injury plaintiff can have volumes of potentially relevant data sources, not only through hardware such as cell phones, iPods, and flash drives, but also through information stored on various internet sites that enable the sharing of pictures and video, chat rooms, blogs, social networking, etc. To adequately address the challenges and potential consequences of custodian self-collection, in-house counsel should seek to develop an e-discovery process that preserves ESI in a systemized, repeatable, and defensible manner. An e-discovery process that uses enterprise search and collection tools for responsive data collection from all prospective custodians will assist counsel in limiting their organization's exposure to spoliation sanctions and penalties while facilitating compliance with the federal rules of civil procedure.